Hello guys, welcome to my YouTube channel. Today we will discuss about our next chapter, that is performance of contract. What is performance of contract? Contract performance is the process of fulfilling the obligations outlined in a contract. It involves delivering goods, providing services or making payments. What is involved? Terms and conditions, timelines, quality, non-action. Terms and conditions: all parties must adhere to the terms and condition of the contract. Timelines: all parties must meet the timeline specified in the contract. Quality: all parties should agree on the quality of the goods or services. Non-action: contract performance can also involve what parties have agreed not to do. Now, what happens if a contract is not performed? If a party fails to perform their obligation, the contract may be terminated. A breach of contract may occur, which can lead to disputes and litigation. A breach of contract can damage a company's image and result in legal penalties. Now, types of performance: there are two types of performance. First one is actual performance and second one is attempted performance. Actual performance: this is when both parties fully execute their contractual duties, effectively discharging the contract. For example, a seller delivers goods to a buyer on the agreed date and the buyer pays the full price. Now, attempted performance: this occurs when one party is ready and willing to perform their part of the contract but is prevented by the other party from doing so. For example, a seller shows up to deliver goods on the due date, but the buyer refuses to accept them, claiming they are not needed anymore. Now, tender. Attempted performance, also known as tender. Tender is when a promise offers to perform a contract, but the promisee refuses to accept the performance. This can discharge the promiser from their liability and performance obligations. अब देखो इसके एक्सप्लेनेशन देखते हैं हम इसमें क्या क्या होता है. एक होता है इसमें ऑफर, एक रिफ्यूज़ल, डिस्चार्ज. Offer: the promisor offers to perform the contract. Refusal: the promisee refuses to accept the performance. Now, discharge: the promisor is discharged from their liability and performance obligation. Now, example: if a seller offers goods to a buyer but the buyer refuses to accept them, the seller is discharged from further liability. The seller may sue the buyer from breach of contract. Now, conditions for a valid tender. The tender must be unconditional. The tender must comply with the terms of the contract. It must be made at the fixed or proper time and place. Proper opportunity of inspection. The tender must be whole. It must be made to proper person. It must be made by a person who is able and willing. Tender of goods must be for the quality and quantity agreed upon. A contract may be performed by following persons. First one, promiser, the party who takes the promise. Next one is agent, a person who is authorized to act on behalf of the promiser. Next, legal representative, the representative of a deceased promiser. Next, third party, a person who is not directly involved in the contract but is asked to perform it. The Indian Contract Act of 1872 defines who can perform a contract in sections 40, 42 and 45. Example: if Peter promises to pay John rupees 50, Peter can perform the promise himself or ask someone else to pay John. Now, who can demand performance of a contract? The promisee. The promisee can demand performance of the contract, and the promisee's legal representative. If the promisees die, their legal representatives can demand performance of the contract. And a third party: in exceptional cases, a third party may be able to demand performance in exceptional cases, such as when they are the beneficiary of a trust. Now, time and place of performance. The time and place of performance of a contract are the moments or period when the parties involved must fulfill their contractual obligations. These are essential aspects of a contract. Now, when and where to perform a contract? If the parties agreed on a time and place, the promisor must perform the promise accordingly. If no time or place is specified, the promisor must perform the promise within a reasonable time and place. If the promisor is to perform the promise without application from the promisee, they can perform it during the usual business hours on the agreed day. Now, factors that determine the time and place of performance, the intention of the parties, the nature of the contract, and whether time is the essence of the contract. Now, examples of contracts where time is important: business contracts, construction contracts, transactions, land and property dealing, allotment of plots, renewable rights, carriage by air, sale of shares. Now, rules regarding time and place of performance. The Indian Contract Act 1872 specifies some rules regarding the time and place for the performance of contract under section 46 to 50. Now, performance of reciprocal promises. The performance of reciprocal promises is governed by the Indian Contract Act 1872. The Act states that the performance of reciprocal promises depends on whether the other party is ready and willing to perform their part of the agreement. The rules regarding the performance of reciprocal promises are outlined in the Indian Contract Act 1872. These rules includes order of performance. If the contract specifies the order in which the promises are to be performed, then they must be performed in that order. If the contract does not specify the order, then the promises must be performed in the order required by the nature of the transaction. Now, revocation of acceptance. A proposal can be revoked at any time before the acceptance is communicated to the proposer. Non performance. If one party prevents the other party from performing their promise, then the contract can be declared void. The party that was prevented from performing their promise can also claim compensation and for any losses they suffered. Impossible promises. If the promiser promises to do something that they know it is impossible, then the contract is void. The promiser is also liable to compensate the promisee for any losses they suffered. Simultaneous performance. If the contract requires the promises to be performed simultaneously, then the promiser is not obligated to perform their promise unless the promisee is ready to perform their promise. Now, appreciation of payments. Appreciation of payments is the process of applying a payment to a specific debt owed by a debtor to a creditor. The debtor is usually the one who decides how to apply the payment, but the creditor can also make the decision if the debtor doesn't. Now, the rules regarding appreciation of payment are outlined in section 59 to 61 of the Indian Contract Act of 1872. These rules apply when a debtor owes multiple debts to a creditor and makes a payment. Appropriation by debtor. The debtor must inform the creditor of the payment. The debtor must indicate which debt the payment is intended for. The creditor can refuse any conditions made by the debtor. The debtor must prove their intention to appreciate the payment. Now, appreciation by creditor. The creditor can use their discretion to apply the payment to any debt they are owed. The creditor can apply the payment to a debt that is barred by the Limitation Act of 1963. If neither party appreciate If neither party appropriates, the law will apply the payment to the debts in order of time. If the debts are equal, the payment will be applied equally to each debt. Now, assignment of contracts. An assignment of contract is a legal process that transfers the rights and obligations of a contract from one party to another. The party transferring the contract is called the assigner, and the party receiving it is called the assignee. How it works? The assigner transfer their rights and obligation to the assignee. The assigner is relieved of their contractual duties, the assignee can enforce the contract against the other original party. The assigner remains liable for the contract unless explicitly released. Now, types of assignment. Contract assignment. The assigner transfer all rights, obligation, and responsibility of the contract. Now, assignment of rights. The assigner transfer only the rights of the contract. When assignment can occur in various contexts such as leases or sales agreement. Not all contracts are assignable. Some contracts contain clauses that prohibit assignments called anti-assignment clauses. In the Indian Contract Act, assignment of contract is covered in Section 37 of the Indian Contract Act 1872. Thank you.